and Chartered Institute of Builders. He is a highly experienced contracts and commercial director with extensive leadership across Qatar and Kingdom of Saudi Arabia. We are honored to have him here share his insights and experience with us today. And also, a kind request and announcement to the participants. Please keep your microphones muted during this session and feel free to post your questions in the Zoom chat. We will have a question and session at the end of this CPD. Without further delay, I would now like to hand over the session to our distinguished speaker, Mr. Ghaffur. The room is yours. Thank you.
Yeah, good evening, everyone. Thank you so much, MCC PPA Qatar Wings. It's a privilege. It's an honor in participating MCC PPA Qatar Wings. The Muslim Central National College is actually shaped every one of our character, our disciplines, and our path in life. So the school provided us the foundation that brought us in this stage. Supporting to the school, it is not optional, it's obligations. So we stand here with gratitude, with respect, and with a duty to give back the place that drives us. But I know many of you are not from MCCC, but I want to give one message, whoever belongs to MCCC, that they should stay connected and be part of it, regardless of the status or criticism or the background or the positions whatsoever it is, or the personal view. Doesn't matter. The matter is the bond we share with our school and the duty to support it with the unity and respect. Somebody can tell me that my screen is full now. I'm trying to make my screen full.
I hope it's not yet in the full screen mode, so you can try again.
I made it already. I don't know.
No problem. You can proceed further. No problem.
Yeah. I don't know. I made it. Okay. So thank you very much, everyone. We are today to talk about one of the very important subject, apart from we call it as a close in FIDIC 2017 Red Book. It is a metaphor every construction personnel's, or else we call it as a quantity surveyor, contract administrator, claims manager, commercial managers, engineers, site engineer, project manager, whoever it is. This understanding is important, and it's a vast. That's why I requested MCC admin to provide me the 4 hours time minimum. Unfortunately, that is not possible, but we will continue. So clause number 8, what is it about? What is it about? It's about the commencement and delay and suspension. So this is bringing to the mind 3 important matter of the construction project cycle. What happening? The clause is forming the core of the contract. I will call it as a time management framework, right? So it is governing every time related obligations from the moment that the contract agreement is signed until the taking over certificate, which the engineer issue the taking over certificate. Nothing in the projects or constructions phases operates outside the influence of this clause. Everything is covered. Everything is, we can call it like layered. Every schedule, every day, every progress update, every time adjustment, and every interruptions of the works, it is fall under the clause number 8. That was the reason I always choosing this to teach the students about this clause. The understanding about this clause is much important than anything. Now, we all are working as a quantity surveyor or contract administrator or engineer or commercial manager, whatever it is. Now, we manage time through this clause. We rely on everyday functions, everyday activity, because sorry, there's some interruption. I don't know. Because I need to make a full screen to my, let me try now. No, it's not getting success, I think. I don't know. Anyway, what we are talking about. So we rely on this, and this is the clause that guiding us and everything on it. So what is it providing? First, when the project starts, we go for the mobilizations decisions, and we are evaluating the progress and the review of the overall planning documents and the assessment of the delay cost, and we are assessing the delay damages, or we are talking about delay damages or liquidated damages. So it defines when the employer holds the authority, power to suspend the works, and when the contractor must restart them. When you deal with the disputes, over the time of the projects, you come back, you referring to the clause 8, along with the clause 20, which is the very vast subject as well. Now, when you defend the challenges on your UOT, you have to interpret the clause 8. When you manage the risk, you measure your action against the procedure. The all are built into the clause number 8. That's why I'm talking about clause number 8 vastly. Because when you open the FIDIC, you read it. It is structured. It is simple language, because FIDICs are written by the engineers, not the lawyers. That's why it is very famous in the international wise. But to go into the deep, that talk about how we deal in the day-to-day life, and what are the triggering points that come to our mind, and every day how we can challenge those. How do you interpret? How do you defend? If you are working with the contractor, how do you interpret that a moment? And because the disputes or the conflict coming from the way that how do you interpret, the way that how do you defend the case, if you can justify, if you can defend, So the clause number 8 control when the contractor to commence the work, because the contract doesn't leave a commencement date, or we call it start date, open or flexible. No. So it is ties. It is ties with the defined event and the control by the employer through the commencement notice. So what's happening, for example, I'm talking about the starting point. What's happening when the project is touch the start button? That is an event. So the FIDIC number, clause number 8, guiding and explaining how that has to be done. It's just not contractor sign the contract and go and start the work as, or the employer waiting for the contractor to start the work because of we signed the contract, for example, taking as an example for the first event. Because the employer gains the security that contractor will not mobilize before the employer fulfill the key obligations. What are the key obligations then? There are key obligations before the commencement date. From that, the contractor gains the protection against the claims of late mobilization when the employer has not issued the necessary notice. So you understand that, both parties. Now, here the balances come out. So what do you understand from here? That should be a notice from the employer or the engineer to the commencement. And there's a key obligations to be fulfilled before the commencement. Then the clause number 8, move from the commencement to the broader structure of the progress to control, how the progress is measured throughout the project, which is required program. What is there in the program? We all call program. If there is a planners, you know about the program. All the constructions professionals is aware about the program. But what is there in the program? What we talking about the program, what is there? It should reflect the logical sequences and the critical part. I will explain you what is critical part. And the program, what you call procurement plans, because you need to have the procurement plans. When are you going to have the material X and Y set, and your resources plans or level, whatever it is. These all should be there. So what is that program? It's not just the planning tool we're talking about. We're talking about contractual tool. It's not the planning exercise. It's a contractual tool, control everything. So the program giving you the basis of comparing the planned progress with actual progress. You plan something, whatsoever the reason, and most of the time it doesn't happen. So the actual is always vary from the plan. Always varies from the plan. 99.99 whatever the percentage. I never heard about any project that is exactly the time finished. There are projects 1 or 2 we don't know, but yeah, that's what's happening. So always there is a difference. Always there is a variance about it. So that is why for the contract administrations, we should understand about the program as well. As the work proceeds, now the close number rate becomes the reference point how the delays are assessed. Because the delays occur on every project. You need to understand something. A close number rate doesn't prevent the delay. It doesn't prevent the delay. Delays are naturals. So the close number rate provide rules to identify the cause and the assigned responsibility, and they determine the impact on the time for completion. It can be caused by the employer, delay caused by the public authorities, delay even caused by the contractors, exceptional event, delay arising from the variations. So it is setting the boundaries of entitlement. Now, if you know about clause number 20, the contractor's claims, and that is a procedures, see both together. Right? I know I haven't started the slides yet. I'm just talking commonly. I'm not started yet the clause number 8.1. I'm talking broadly because I was requested to explain broadly the things. So I'm just explaining what is clause number 8. So when I go technical part, then you will be understanding anyway. So when the delay arises for the reasons outside the contractor's control, clause number 8 guiding when time must be extended. What happens if the time is not extended? The contractor gets penalized, which we call most of the time delay damages. You agree to complete the project on certain time and you delay now. How do you decide? Who is responsible for that? If that is not contractor, how can you penalize him? So you need to have a mechanism to extend it. So the contractor get the protection through the entitlement on extension. But how do you get that protection? How do you get that protection? Is it that automatically? No, you don't get automatically, right? You don't get automatically. You should follow the procedure. You should issue the notice. You should have records. You should demonstrate the evidence, which is linked to the updated program. Now, you created, we call it proper procedural method or transparent method of adjusting the time. Now the engineer, he will evaluate the delay cause, review the program, he will analyze the fact on the critical part. He will come to the fair determination then. Now, if the contractor doesn't complete the work within the time for completion, as suggested under the contract, so the clause number 8 giving you the explanation when the employer can impose the delay damages after the time or revised time for completion expire. It will continue until the taking over certificate be issued. Then clause number 8, giving you the overall picture about the employer authority to suspend the work for any reasons. And there is a cost, there is a risk, there's a resources. So when we're talking about the suspension in this clause, FIDIC is restricted the suspension to the written instruction which has to be issued by the engineer. So this is overall about when and how the work must be resumed and how, this is a very good. Why this clause exists? Somebody thinking about it. Why this clause exists? Because it's created the structure system to manage the time. Without this structure, the construction contract will be uncertainty. And your schedule would be undefined. And the delay become argument, disputes. Your performance could not be measured. And the consequences will be unclear. That is prevented by the clause number 8. So it's not just time for commencement, starting with like what you call suspension. It is a structured procedure. Because every construction contract must find a balance between two opposing forces. The contractor has a right to manage the work and the employer the rights to receive the work on time. Because contractor will have his own method, his own planning, resources, sequences. But this freedom is not unlimited. The contractor has the freedom to plan his own, and he has a sequences, and he must have the resources his own. But there is the freedom of this kind of things are not unlimited. The contractor must still complete the works within defined period. This is where the clause number 8 coming to the picture, because it's imposing.
Your voice is broken. Let me check, please.
Hello?
Your voice is broken.
Broken?
Broken means continuously your voice not clear.
Hi, sorry to interrupt. It's very audible, and Mr. Muhammad Ishaq, kindly check your network connection. Maybe it's due to that one. And I hope
Yeah, my Wi-Fi
everyone
is
is
also is good. It's okay. Anyway,
okay.
continue, sir,
Yeah,
please.
thank you. Thank you.
Yeah, okay. Thank you for letting me know, but sorry for that if there is any interrupt, but I think it's fine. So, okay. So as I'm continuously, because when the flow stop and it will be very difficult to restart. So we're talking about clause number 8 generally. So it is the primary tool of the contract, managing the time and risk when the project start to sleep, or if there is any issue when it is happening. You don't go to immediately clause number 20 or clause number 13, let's say. You don't go that immediately. Your first point of control is the clause 8, because clause 8 is capture the first sign of the delay, and it is contained the tool that allow the project team to recognize the problem, and it has a measuring tool of that impact and the action taken. If you don't manage the time issues correctly here, then your delay will grow. The record will be incomplete, and your future claims will be rejected most probably. Right? So you have 8.1 to 8.13. You have 8.1 to 8.13. On that, each of them has a very strong, very valid things. We are the contract administrator or the quantity surveyor, a commercial manager to talk about. Now, what if there is no clause number 8 in the contract? I just want to come to the point. I want you to think about it. There's no clause number 8. What we call about it? What is that actually? If there is no clause number 8, what will happen? You don't have a completion date. You don't have a commencement date. You don't have extension of time. You don't have anything. They call it time at large. Before moving to the clause number 8, I just want to cover this critical legal concept that which I will call it. That is not especially the FIDIC is talking about. But in practical, you should know about before you learn about this clause. What is that time at large? Time at large, the contractor is no longer bound by the time for completion stated in the contract, or if there is nothing stated in the contract, or the date of completion no longer applies. Instead, the contractor become obliged to finish the work within reasonable time, that is based on the circumcision of the project. In other words, I'll call it as there's no longer valid enforceable completion date. Delay damages can no longer applicable. Termination for the late completions become very difficult. The contractor gain flexibility in timing in the litigation process maybe. The employer loses the enforcement power if you don't have a clause number 8. So the idea of the time at large, born from the common law actually, in English law, which in the legal framework in many FIDIC usings, jurisdictions like UK, Singapore, Malaysia, Hong Kong, etc., whatsoever it is. But under the common law, there's a principle known as the prevention principle. So that says a party cannot help the other party to a completion date if the delay was caused by its own action, unless the contract provides a proper mechanism to extend that date. So if there's no effective EOT mechanism or it is ignored, then the completion date is no longer enforceable. Time becomes at large. So a FIDIC are designed to prevent time from becoming at large. That is the clear mechanism we are today studying about, clause number 8. because you should understand why these clauses exist, why it is important. So let's say you are creating a bespoke contract. What is bespoke contract? The bespoke contract is you are creating for your own requirement, or it is differ from the FIDIC, JCT, and NEC well-known standard contract that is called bespoke contract. So most of the time in Gulf countries, we create the bespoke contract because nature of the project, a special requirement by the employer, it's different. So if your contract administrator missed that, a clause number 8 or whatsoever the clause talking about, the extension of time, then that is the most difficult part. You understand? So that is why the clause number 8 is exist. So we'll talk about now. I bring it to the slide before starting the clause number subclause 8.1. We have a clause 1 in the FIDIC which talk about definitions. On that definitions, you need to go back and see what is commencement date, what is time for completion, what is taking over, what is climb, what is delayed damages. Because I'm not going to explain, because if you are not from the construction industry and you want to eager to learn about it, you go back and see that what is commencement date, and it is clearly mentioned about each of the item, right? So, and also the clause number 8 is linked to the many other clauses in the FIDIC. For example, taking over, clause number 10, when the time for completions end. Because taking over is a benchmark that most of the contractor obligation become ending. That's the benchmark. And your delayed damages run until the taking over, the works are taken over. And the clause number 13, it's about the variation, or we call it change management procedure, that is linked to the clause 8, you should understand. Because most delays on the projects come from the variations, clause number 13. That is govern how the variations are instructed and value. But one, the variation affects the sequences and duration and the resources of what you have planned for your works. It's affected time. But this is where our clause number 8 come in. Then you have a clause number 14, contract price and the payment. For example, if the contractor is delayed due to the reason for entitlement of the extension or the cost, and the delay will have a commercial sequences. Example, prolongation cost during the suspension, for example, additional site overhead due to the employer cost delay. So the time you have a cost, and the time extension without cost, with cost. We will learn about it. And you have a clause number 17 about risk event. Clause number 20, mostly interconnected with the clause number 8, the claims. That's a procedural, or else we call time bar. You have a time bar. Why we call it time bar? I'm touching because you have to be fully aware about that. The deadline of issuing the notice of claim is 28 days, for example, or it's depending on your contract. I'm talking about FIDIC. Then you have a deadline of substantiating or submitting fully detailed claims, 84 days, unless extended, you both party, contractor and the engineer, agree, or whatever the case. Now, this is a time bar. You can't miss this time bar. If you miss this, your claim most probably rejected. Then you have a close number, subclause, we call it subclause actually, 3.7, engineer determination, because he will assess whether a delay occurred, whether delay entitled to an extension of time, how much time should be granted, whether delay damages are due or not. This all he will decide. Right? That's what we're talking about, clause number 8. Let's jump into the clause number 8.1, commencement. What is the problem is, when I was arguing or discussing about the clause number, subclause 8.1, the clause is sometimes misunderstood. Commencements of the work. Because every calculation of time for completion, delay, entitlement, if you misunderstood, if you have a different opinion about it, will be built on the wrong assumption. So when the contractor must commence the work or start the work, this sounds simple. But in many larger major construction contracts, when hundreds of activities depend on the mobilization and the delay remages run into thousands per day or millions per day, the answer must be a formal and enforceable. You may understand what I'm talking about. I'm talking about the commencement. Every calculations, everything start from that commencement. So what is that enforceable under the FIDIC, the commencement? How that is starting? So the engineer shall give the notice to the contractor, starting the commencement date, not less than 14 days before the commencement date. So the obligations and the duty of the engineer start there. Note the point. What does it mean? Now the engineer hold the authority to active the contract schedule, but that authority is ties with the specific obligations. What is that specific obligation we call it here? The engineer must issue the formal notice. The notice must be clear, state that the commencement date, and that notice must be issued at least 14 days before that date. Why 14 days? Why not 25 days? Or why not 5 days? Think about it. Because you need to provide the contractor for the fair and reasonable period. What he has to do, he has to mobilize the personnel. He needs to deliver the plant, equipment. He need to set up the site offices, facilities. He need to start issuing the notice to the subcontractor the same way that, unless, if not, he needs to start coordinating with the supply chain. So he needed time, minimum 14 days. What happened then if the engineer sent the notice only 5 days before the started commencement date? The answer is it is non-compliant. The contractor could challenge its validity, the time for completion start. That's the other part, how you challenge, how you have to challenge. I don't go further deep. That's why I told you. I can go further deep of this matter we talk about, because if the 14 days notice is still not sufficient for the valid reason and justifiable reason, how to handle that matter, you need to think critically. So you don't take as the sentence that is there in the book, or you don't just take that as someone teaching you like me as it is. What you have to do, you have to think in a multiple branch. You have to think critically the matter, how that is handled. If that is happen, what will be the justification, how we can handle? Let's say you don't have a I mean, you fail for the reasonable reason, for justifiable reason, the commencement date. There are a lot. And how do you handle that? You have to think about it. And the situation, what we can do is, what I can do is I can give you the little bit broader about disclose, but you need to think about multiple way. That was your critical thinking will sharp you, will bring you the person, the strongest person in the claims and the contract. That is number one. Especially the people who work under the contractor has a more opportunity to talk about a critical thinking, how we challenge. Is that correct? Is that reasonable? The second part of the commencement's about unless otherwise stated in the particular conditions or the contract data. What is particular condition? You have a two condition. The people who may be not aware about it, general condition, standard document, for example, FIDIC, JCT, NEC, etc., as it is, general condition. You have opportunity to amend the clauses, add the clauses, delete the clauses as per your requirement. That is called the particular conditions, which is hierarchy, higher than the, what do you call it? Higher than the priority of the general condition. If you say something on that general condition, 14 days, you can amend it. Then both parties agree. So unless, if that is mentioned in the FIDIC particular conditions, so the commencement date shall be within 42 days after the contractor received the letter of acceptance. So you have a 2 point, you have a 2 track. What does it mean actually? Maximum time window. That's what the FIDIC is introduced to you for the contractor and the whole party for setting the commencement date, maximum. By default, the commencement date must fall within 42 days after the contractor received the LOA. So you have obligations. So regardless, we can say when the engineer issue the notice, the commencement date itself must not be later than 42 days unless you have a different things in the particular condition. So you prepare the resources plan accordingly, set up the early procurement, confirm the availability of the subcontractors, know when the time for completion start. So you receive the LOA, let's say March 1st, and you have a 42. So you have a permissible on the commencement date for, if it's March 1st, then around 12th April. So the engineer should issue the notice 14 days. That means 29th of March. So if the engineer delays the beyond this point without any reason, then there's opportunity for contractor. What is that opportunity? You have to use the clause number 20 for that. That's the contractor's claim. The one thing I want to remind you guys, the letter of acceptance mention date January 1st. For whatsoever the reason, contractor receive that LOA on 20 days later. So what is the date here? It's not that date is mentioned, actual receipt, not the date for issue. This is a potential dispute point if that is not documented. So what is your duty as a contract administrator? On the contractor side I'm talking about. What is your duty? You need to document that. You need to record that. You need to say even by the notice, by the letter, whatever it's. So I'm just talking about step by step. Now, a part 3 of this 8.1 is talking about contractor obligation to commence the work. Now, the contractor shall commence the executions of the work on or as soon as reasonably practicable after the commencement date. What is that reasonably practicable? So you need to be ready to commence the executions on the commencement date. If that is not practical, then as soon as reasonably practicable, what does it mean about that? Why the FIDIC introduced this kind of, flexible term? Yeah, this is flexible, but it is not open-ended. You're not open completely freedomly. It's not open-ended. It's allow for the minor justified, let me correct my wording, minor justified delays based on the real constraint. What is real constraint we're talking about? That is real constraint. What are the possibility of risk? Let's say short weather delay at mobilization, minor customs clearance on the equipment. We saw issues that you take all the steps to mobilize the laborers from some other country out of the border. You tried everything, but it happened minor delay. So it should be justified delay. Therefore, you have a small flexibility on that. Reasonably practicable. That is reasonably practicable. Not just you can go back and say, come on, engineer, we have in the contract that reasonably practicable so that we can delay another 3 months because we did not, our supplier did not comply with our terms and we finding another supplier. So the reason, no, it's not that. So that point, engineer will come to challenge the unjustified delay. So what happened? If you delay, then that is coming to the picture. Engineer will issue the notice to you, right? Possibly, if it is invalid reason provided. So your duty is obligations of the contractor. Start immediately your work, unless that is very clearly impractical. Very clearly impractical. Then you need to proceed with the works with a due expeditions and without delay. This is creating you the continuous obligation for you. I'm talking about the contractor. Because you need to work actively, the consistent, and everything is reasonable, not to slow down the progress unnecessarily. So very importantly, if the contractor start on time but fail to resource it properly or work at reduce the pace, now the employer may issue the notice that's saying you failed with the proceed with the due expedition. So we all talking about the 8.1. How many trigger point here? How many trigger point here? I'm talking about how they can come and backfire you with a sentence. You say reasonable a day duration, right? Then it says proceed with the due expeditions. Due expeditions, what is that? Due expeditions. So they can issue the notice under this. You can fall under the behind the program. Early in the project is happening. Your works have a cabs, and you mobilize too few laborers and plants, not all. This is what happening everywhere. It's a very common. Nowadays in the project, it's a very common. So if the engineer failed to issue the notice, then did the contractor has obligation to start the work? I'm asking you guys. Is the time for completion is still the same? Is the delayed damages can be applicable? You have to think about it, because you have a two time frame. One is 14 days, one is 42 days we're talking about. I'll leave it to you to think about it. I want you to think about it. As I told you, the engineer must issue the commencement notice at least 14 days before the commencement date. And there is a maximum time frame for the starting the work within 42 days. Right? And the two important points I talk about, reasonably and practicably. And I talk about due expeditions and without delay. You understand? Can the employer terminate for non-commencement of the work? Yes. If the contractor fails to commence the work without justification, the employer may start termination procedure. If you fail to commence the work within reasonable time, when it will be a problem, sometime, I'm just not pointing out anyone, I'm just telling, sometime, maybe, let's say there's an issue, any issues, or employee changed the mind after the immediately issue the letter of acceptance, or he has some funding arrangement is not goes fine, well, then you, or he has immediately changed the mind to change the contractor with the immediate effect, or to finding opportunity to give it to someone else, because between that the communication not went well. You're giving opportunity to the employer without commencing the work, right? But anyway, there should be a notice of default from the employer, and there should be a opportunity given to the contractor to correct the failure. It's just not happening in over the night. And if the contractor had a valid reason, for example, the access is obligation of the employer, the rights of the contractor, providing the access. So if that is not provided, then you can't just do that. You can't just do that. But there just be a justification. Now the time for completions. We talk about the commencement, time of completion. Now everything that follow in clause 8 delay, extension of time, delay damages depend on this clause. The duration of the contract, when must be completed by the end of that duration? When the contractor considered to have fulfilled the time obligation, the link between commencement and the date of completions. So this is about original contract time frame. It's not about extensions. It's not about delay or something. It's about original contractual time frame agreed in the time of contract signing. So where is the time for completion is mentioned then? It is not mostly in the general conditions. Go to the particular conditions, because the commencement date and the time for completion is always in the particular conditions, right? So the contractor shall complete the works within a time for completion stated on the contract or particular condition. The number of days stated in the contract data, which is calculated from the commencement date. That's why I repeatedly emphasize, my dear friends and brothers, the commencement date is always the matter. It's the matter because your time for completion is calculated by the commencement date. So the time for completion is the contractual period that the contractor is given to, number one, complete all the works. If you go to FIDIC, if you go to the definition, you have a works, capital W. So the capital letter is coming to the first letter as a first letter as a meaning given by the definitions of the contract in the contract. The capital letter of the works mean the permanent and the temporary works. Here you complete all the capital WORKS, which is works, temporary and the permanent works. Is that enough? Is that your obligation? No. You have to pass all the test and completion. Is that only? No. You need to be ready for taking over. So what is that? Is that the physical works we're talking about? No. You have two: construction to complete, functional testing complete, commissioning complete, and operational maintenance manual. You need to hand it over. Maybe you need to provide the training to the employer, staffs, how to handle the equipments. You need to provide all the supply chain contact detail, warranties, guarantees, etc., collateral warranties. Is all coming under the completions. You don't just call it, if you say that, hey, we complete our work, please come and take the work. No, it's not the procedure we're talking about time for completions. It is further defined in the clause number 9, what is test on completions. I'm giving the brief, not giving the brief idea about that, and we don't have a time for that actually. We need to run through many clauses. So you have a particular condition, part A and part B, or contract data, part A, part B, or we call it contract particulars. Part A, there will be a commencement date, contract completion date is mentioned. So if the contractor doesn't complete by that date and doesn't have a extension of time,
You're on mute, Engineer Ghafoor.
I think I didn't mute. Somebody has muted, I think, because maybe by
It's
mistakenly,
audible.
I don't.
It's
It's audible now.
Yes, it's audible, but the video has gone.
Gone, sorry for that. Just stay with me for a while. It's happening. Can anyone just tell me that? Is it clear for me? I don't know.
Yes, clear, sir.
Okay,
Yes,
so What must be completed, guys? What must be completed? What must be completed? Contractual scope?
Yes, the scope.
The contractual scope. What is that contractual scope? Where that is mentioned? What does that mean, scope? Contractual scope. Come and talk to me. It's an interactive session. I don't mind to talk. So what is that scope? It's an employee requirement. If it is in the design and build, it is a specification. It's a drawing. You have so many things. Then all test and completion must be passed. All commissioning must be complete, etc. Training, whatever I told you, that trainings, subcontractor, supply chain details, everything. So this is the completions. You need to advise the project managers or project directors. I have advised so many of them. What is completions? Most of the people say substantial completion is just finish the work. What does it mean? Or the practical completion is just finish the work to taking over to we can get the retention. It's not that. It's not that. The completion is defined under the contract in a many way. So when that clock start, when that clock start, can anyone tell me when the completions clock actually start? Can anyone come and tell me? So the clock start on the commencement date. The time for completion start, a clock start on the commencement date, not the contract signing date. So the commencement date stated in the engineer notice, which we learn about it. Unless if the delays meets the ground that is mentioned subclause 8.5, which is extension of time, and if you follow the proper procedures set in clause number 20, and that extended time become adjusted, or we call it revised completion date, or adjusted time for completions, revised, whatever it can call. So the delay is not only measured against this updated deadline. So it is important to understand. It is important to understand if the contractor fail to complete the work, including testing and whatsoever commissioning and documentation by the end of the time for completion, it will be exposed to the delay images. Now, if your particular condition, or I call it the contract data, is unclear, or the completion criteria are not well defined, what happens? There will be disputes about what completion mean. You need to be very careful before you signing the contract, or before you drafting the or after you drafting the contract. While you are reviewing, while you are signing, or you're advising your management to signing, you need to be very clear what is completion mean, guys. It will give you the disputes. We don't focus on this matter. I have a claims daily basis from the subcontractor, from the employer, from the contractors, which I'm dealing with, a small wording, interpretation of the small sentence, nothing else. A time for completion mean what? Incomplete definition. So you have to state that the number of days, you have to clearly state that. And the completion obligations, you need to be detailed in the employer requirement. But if the contractor experienced a delay, but failed to submit notice within 28 days or in accordance with your contract, then you fail to submit the supporting documents and the program impact. Well, then your time for completion remains unchanged. Very be careful. This is the most important point that everybody should keep in mind in all the project. So what you have to do, you need to have a proper tracker. I'm talking to every one of you, whether you senior quantity surveyor, a quantity surveyor, contract administrator, commercial manager, whoever, engineer, project manager. What I do every week, I set the time and the day to review all the notices and the changes and the events happen, because I need to notify within 28 days if I miss something. So how that change is happening, you need to create the tracker, you need to create the protocol for that. For example, you have a design department. That department identify anything that has to come through this certain channel, end up with your table or your email box. Immediately you log into that and you start processing the notices immediately. If you miss today or this week, next week it should alarm you. If you really miss 28 days, forget about the claim. So you should not be the reason for the millions of dollars or real to be lost in your company. Don't be silent on that matter, because let's say you submitted the notices within 28 days and the full particular or interim particular should be submitted within, let's say, another 28 days, or full particular is 84 days done. You miss that, or you are going to miss that, or you are unable to do that. What are you going to do with that? You should inform to the employer, the engineer, stating that with the reasonable reasons, justifiable reason, we will submit, we kindly request to extend that period for this. It will protect you in the court. I don't say that the engineer may accept it or reject it. That's a different argument. But for me, my cases, most of the engineer has accepted that. But it will protect you in the court, in the legal system, in the arbitration. So if the contractor believes it has a completed, but the engineer disagree, but the works are considered not completed, only the taking over certificate, which I told you in the beginning, clause number 10, will decide that. It will confirm the completions. Right? So the next slide, we talk about 8.3. This is a program. another important point here we need to talk about. So what happened? You're planning your activities depending on how the task related to another. You need to understand, if you are not the planner, planners can easily understand. So one activity is depending on other. In the construction, it's a sequence. We call it sequence. One is linked to another, relates to another, which a task must finish before the next can start. But it can be happen in the same time as well. Yeah. Let's say a small example. We take about we're building the house. Now you can't start the painting the walls until you finish the plastering. So you can install a plumbing. You can install the plumbing and electrical at the same time, most of the cases. You must finish the foundation before you build the walls. So we call these logical rules dependencies. Dependencies. So the type of dependencies, finish to start, a task, one task must finish before another task start. Then start to start, one task and another task must start together. Then finish to finish. So both tasks must finish together. Then start to finish. Very rare. One task cannot finish until another task starts. Don't get confused. I'm just explaining in order to understand the fact. Why? Because without these links, the program is just a list. Because nobody knows, even the employer, the engineer, how delay affect the project unless they can see how tasks are completed. Then you have a resources loading. Those who are not aware about the program. This is about how much labor, how many labor, equipment, or material are assigned to each task in the program. Let's say you are putting to the, I don't know, I'm receiving a message from admin. We have a very little time. Sorry, if I cannot finish this close, I will do the remaining on the other day, because I need to explain very detailedly, because I want to teach in a manner that everybody understand. I can't just run through the slides so if I cannot finish within the time, we will do it on the next day, the remaining. I don't mind. But let me explain what I won't explain. I think you all agree with me. Otherwise, it's no use to talk about the clause number 8, So you are pouring the concrete slab. Let's say you plan for the 50 workers, 50 laborers, and 2 concrete pump and 1,000 cubic meters or whatever it is, the concrete. Now, if the contractor show this information in the program, so the engineer can check if the contractor is planning realistically, and he can monitor whether the resources on site match the program, because you are promising someone to do this with the program, and the employer representatives and the engineer So who will check that? Oh, the contractor say this. Is it correct? Is it doing that? Is it comply with that? Before that, is that enough? Is that sufficient to contractor say 50 labors, which is not maybe. So you have a concern on that. Hey, contractor, you are talking about 50 labor for this. It's not enough. Maybe you need 75. Why? Because if the progress is slow, then the engineer can see if it's because the contractor did not allocate enough people or equipment. Now, resources loading help identify whether the contractor is complying with obligation to proceed with the due expedition. Now you have a critical part. What is that? Everybody talking about the critical part. If it's delay happen in the critical part, that is delay. If it's what's that? It's the longest sequence of dependent activities in the program, which determines the shortest time in which the project can be completed. Longest part. We call it longest part. So if any activity on the critical path is delayed, the whole project is delayed. Now, let's say earthwork, you have a 10 days. Then you have a foundation for 15 days, so 25 days. Then you have a structure for 20 days. How many days? 25 plus 45 days. You have a finishes for 15 days. How many days? 60 days. Now, if these must happen one after another, so the total time is 60 days. This is the critical part. Now, if the foundation are delayed by 5 days, the whole project is now delayed by 5 days, unless mitigation recovered elsewhere. So only delays to the critical path activity justify an extension of time, because if the task not on the critical path is delayed, but it doesn't affect the completion date, then the contractor is not entitled for time. Then you have a baseline. What is that baseline? We call it baseline. What is that? It's the original version of the contractor's plan. Baseline, initial version, original version, contractor program. Now it's showing that when each activity was expected to start and finish. Now it is frozen and used as a reference. It's frozen, used as a reference. You need something benchmark to evaluate, identify, calculate something. Now you have a current program that will show actual progress. That is include the updates with actual start and finish dates, and the revised forecast and delays, everything. For example, you have a baseline showing that block work start on 1st of March, finish on 31st of March. Now the current revised program show that block work start at 10th March and still ongoing, forecasted on 5th of April. So the completion is delayed, show that activity is delayed and how much. So the engineer used baseline versus current revised program, or current program I call it, to track the progress. All the delay claims are based on comparing a current status of the baseline. So the obligations come from the contractor to the 8.3, saying that contractor must submit the revised program which actual progress no longer matches the baseline. It is your obligation. very strict obligations. You heard about the float calculations. I need to touch this all while we're talking about program, delay, critical. I need to touch this all. What is float calculation then? We call it float or total float. It's the amount of the time activity can be delayed without delaying the project completion date. That means without affecting the critical path. Let's say if the task A can start anytime between the day 10 and day 15, you have a flexible, and still no delay on the next activity, then it has a 5 days of float. So there are two concepts. One is total float. How much activity can slip before it affects the completion date? We call total float. Then free float. How much it can help before affecting the next activity? Because the activities on the critical path have a zero float. That's why it is on the critical path. So floats help identify which activities are flexible. There are many arguments. Who owns the float? Contractor or the project? There's a many argument. So due to the time constraint, now I'm running 9 o'clock. We have another 1 hour only. Advance warning. This is another big subject. Now the 8.4 recently introduced a formal obligation. You need to understand the weightage of what I am talking about. To give the early warning of foreseeable problem. Foreseeable problem. We're not talking about unforeseeable problem. You can't see that. But foreseeable problem, advance warning is a must obligation. Because if either party become aware, so it's not talking about the contractor. It is also saying either party. What does that mean? Both employee and the contractor become aware. So it doesn't require the certainty. Even the partial awareness of the threat is enough to into the obligations. You don't need the full detail of what is going to come. Becomes aware and may affect, may not affect, doesn't matter. But what you have to take it, it may affect. The impact is not confirmed. Probability, not certainty. So what do you have to consider about it? It can be delayed to any part of the work. It may increase the cost, including prolongation. It may increase the disruption or the interference. Anything can happen. So the advance warning is an early warning. When you have to give this, you have to provide, you have to give this before the impact start, not after. Why it is important? Do you know that your claims can be rejected Based on this, the contractor could have reasonably foreseeable this event and not informed to the employer, or the employer could have reasonably foreseeable not informed to the contractor. So they failed to do that. It means that is obligations. It will give you the harm on your claims. So what happening in the real world in the project? Problems rarely appear suddenly. Rarely, very rarely. In most cases, someone sees the risk is coming because you have a risk register, you have a weekly meeting, you have a brainstorm with so many things, and everybody or some people are seeing the problem are coming. What are the problem maybe? What are the problem maybe? Possibly supply chain flags a shipping delay because of XYZ reason. Key subcontractors behind the schedule, as a contractor I'm talking about. Even the drawings are delayed in the design review. Site access going to be blocked. Government permits are moving slower than they expected. I'm talking about very rare, sorry, I'm talking about common cases. So what happened, which I sent to one employer, the advance warning, they written and saying that, hey, don't use the advance warning for smaller thing. Use it something big. This is the response from the employer. I said, that's not the contract say. That's not the contract say. What contract say? If there is impact is I can foreseeable, probability, not confirm. I just informing to you. It doesn't mean that I'm coming with the client, but if there's impact, I'll come definitely because I informed to you. You could have avoided that. You could have advised to take the separate path to that, so that maybe you save your time and I save my time. So guys, this is one of the important things. It's a contractual obligation. Yeah, because it is written in mandatory term. What is mandatory term in FIDIC? Shall. When they use shall give the advance warning means that's a mandatory term. Maybe, or even some other wording. That is not the mandatory term. When you see shall, that means it's an obligation. Now, if anyone fails to give the advance warning, when they know that the risk, then it's your claim is out, and you will be treated as a non-cooperative behavior, and there will be no loss of time and entitlement, and you will even lose the lack of mitigation effort that you have taken, you have now taken. Sometime there may, I don't know, I mean, sometime there may be employee claims against you because of you we have lost. I don't know. If somebody is very smart enough. And it is not the claim notice, you have to understand. So what I saw that some of them taking as a claim notice, or we send the notice under the advance warning so we can submit the claim. No, my dear friends, you have a time clause under the FIDIC where you have to do the notices. But this is an advance warning. You need to follow with the claim notice. It's not the claim notice of claim or fully detailed submission or EOT application. It's a pre-claim signal. part of the early warning system. So if you fail on this, your claim will be treated as avoidable. So this all will happen as I explained. And there are many other things: drawing delaying, supply chain delay, access issues, even employer delay, weather forecast, yeah, permit, risk of the permit, something government is delaying. You don't need to wait. Just send the warning. Don't take the risk. To me, I will not wait for any notice to give until I will start. If anything I am foreseeing, I will not wait to give the advance warning for anything. When the employer may think about, if you are working as an engineer, other part of it, maybe the government regulations going to change, or employer realize that cash flow problem are expected or upcoming quarter, and employer aware that the variation is coming, that's going to be a critical part. This is important. They just employer issuing the instructions directly. You have advance warning. If you have in the mind that you're talking about changing the design, you need to inform in early, so the contractor can aware in early as possible. Correct or not? Correct or not? So that is one of the important latest update given by the FIDIC. Now, another part is about the major part, extension of time. Right? Heavily used, tested, close, extension of time. So the contractor rights to claim the additional time when the delay occur due to a reason outside the contractor control. You remember that 8.2 we learned about the contractor is required to complete the work within defined time for completion. So that obligation starts from the commencement date and continue until the works, including test and completions and everything to be done, and works are ready to be taken over. But projects, 99.9% project doesn't go exactly as planned. Variations happen, approvals are delayed, authority interference are there, material don't arrive, epidemics, COVID-19, pandemic, Red Sea, the things that happened some time ago, shut down the supply chain, whatever the reason. So 8.5, to provide you the contractual relief when the risks are materialized. It's about, you need to remember something, legitimate entitlement. Legitimate entitlement. That's called claim. Legitimate entitlement. For the contractor, based on the defined delay causes, subject to the clause number 20, which is strict procedural compliances. So the clause is providing the contractual rights, which is extension of time, and the providing the ground. So the contractor shall be entitled, subject to the clause number 20.2. What is that subject? Notice, procedure. But the EOT is not automatic. It's not an automatic mechanism that employer delay, you get that, I explain you. It's a contractual entitlement, conditional, claim-based, evidence-driven. It's not automatic. So only if you comply with the submit the valid claim under the 20.2 and the delay caused by the listed event. On this condition, there are many events listed. I cannot go very deeply, which I told you, many events. Then that delays affects the time for completion. You should have a ground. And that delay must be impact the taking over. So the extent that a completion for the purpose of the subclause 10.1 will be delayed, which is taking over certificate. So this is telling us that the contractor is only entitled to an extension of time. The event actually delay the ability to complete the works under the taking over. Because you know that the completion required whatever 1, 2, 3 works completed, test and completion, everything. So if the delay is in fact non-critical work, the activities that are not part of the handover requirement, then there is no EOTs in due. Example, if the delay in the, let's say, facade material that block the building occupancy, it's eligible. But delay is the landscaping work, not on the critical path, not eligible. And I want to tell you something. Here we are coming to the substantial completions, or we call it sometimes practical completion. What is substantial completion? Substantial completion, the employer can use the building without impacting the purpose of that building. That means, for example, landscape is not finished yet, but the building is finished. Yeah, substantially completed. That's a different scenario, right? So the contractor must prove that the delay activity was on the critical path. Critical path is matter. That's why I explain you critical path. That is the point, a benchmark which give you the extension of time and the entitlement. So there are variations under clause number 13. Any changes on the scope, quantity, method, sequence. Again, a change management is a different subject. We need to talk about hours, so I don't want to touch that. But either instructed by the engineer or approved under the variation procedure. You have two things. Change management work in a many way. Either instruction, proposal, you submit and engineer approve. And engineer requests the proposal, you submit, then approve. So there are change management work in a different thing. So the variations instructed or approved under the variation procedure. Let's stop that here now. Now that variation is affect the critical path. You don't have a pre-revised EOT on your, which include the variation. So contractor can submit under the 8.5. That's why when you are submitting the variations, don't sign the variation or don't say that there's no time. will be submitted in due course. Time will be evaluated, or contractor is preparing the time impact of this variation, which become available, something like you have to protect yourself. Then there's a delay, disruptions by the employer personnel. Oh, there is another contractor work for the employer. What are those may be the time. Somebody mic is on. Can you please? We have no time, so please just mute your mic, please, my friends. So those are like late site access, delayed in instruction. I want to talk about delayed in instruction. Instructions may be the instruction form of instruction. Or let's say RFIs come with instruction, IFC drawings come with a, design changes, something. So you have to understand, and you have to deeply analyze that is different scenario. But I'm talking about delayed in instruction. Then the late approval, which is 1.9, very famous clause. And most of the extension of times are coming with this subclause. Then non-performance by the employer, separate contractors. There will be many contractor who is non-performing, so that late payment. And I know that it's depend on your contract. For the late payment is different because some of the contract particular conditions are removed that, and you have to see that. Anyway, if that is impact the critical path, that's what I am coming to say. So you need to identify the action or inaction. It's not just action. You have to link it to the specific contract breaches. You have to prove a time impact through the program. Now, for example, employers, subcontractor block the access, or contractor block the access in the critical area. Yeah, you have employer failed to issue their drawing on time. Yeah, something employer causes minor inconvenience which is not in the critical part. So no, you don't have that. Then you have an exceptional event which is unforeseeable, beyond the control of the both party, and not due to any of them fault, any of the party fault. Civil war, pandemic, natural disaster, government emergency order. So the contractor must prove the causation of a delay. And very importantly, your flood must be exhausted. Impact must be on the critical path. But when we come to the cost, that's a different subject. Right? Let me explain in final touch, because you have another half an hour, if I'm not wrong. Then delay due to the ruling, order, public authority, courts, government. This is not exceptional event. It's a legal risk. Now the court order work to stop until the pending resolution of the land disputes. Otherwise, as I told you, local authority block the road access because of environmental issue. Now here, the delay due to the binding external legal order, not an act of the employer or the contractor. To claim EOT, the contractor must demonstrate it doesn't close, otherwise it is not matched with the illegal things what you are doing, or you are complying with a legal order. You understand? Then you have a unforeseeable shortage due to the epidemic or the government action. This is important. COVID-19, border closes, government export ban, shortage of labor, material, if there is, and if that is cause linked to the governmental or the epidemic, shortage was unforeseeable. That's important. I need to talk a lot, but I have no time. This is unforeseeable. If the experienced contractor could have seen foreseeable, that is different thing. At the time of tender and the impact delay, the critical path, then again, right? So the ground focuses on the availability. I'm not talking about here force major status. So we need to define what delay it is. How does it? You understand? Because you have a 20.2 where if you don't follow that procedure, again, you lose that. Right? The engineer has the role because engineer will decide under the clause 3.7, he has a duty to act fairly, objectively, based on the facts, whether the EOT is valid, what extension of, if any, is due, what is the revised completion time. And if you don't agree, go to DAB in 1999 FIDIC or DAAB, Dispute Adjudications Board, or Dispute Avoidance and Adjudication Board with the FIDIC 2017, or arbitrations as per your dispute solution. That's a different thing which I want to touch you. So for that late notice, you lose your entitlement, weak program, and you don't have a proof of the critical delay, right? You should be careful identifying the valid EOT, the causes, and the link. You have to show the actual delay, and you have to provide the impact on the critical path, timely notices, update the program. I want to touch you very important because I forget to tell you about the concurrent delays, which I have not added in the slide. What is it, concurrent delay? Many people talking about concurrent delay. What is it about? The concurrent delay occur when two or more delays affect the project at the same time. Try to understand, please. The concurrent delay is about two or more delays affect the project at the same time. And one delay caused by the employer or the engineer, and one delay is caused by the contractor. So the both delay must affect the completion, and it has to be occur in the same time frame, not in the overlap of the calendar terms. Why? Because concurrency matters become directly effect of the contractor entitlement to the extension of time and the employer rights to impose the delay damages, and you can't claim for the prolongation cost and everything, etc. So if the contractor delay a party due to its own fault and partly due to the employer caused delay, then should the contractor get more time? Or is the employer need to impose the delay damages, liquidated damages? Or should the contractor has to be paid by the prolongation cost? These are the questions. These are the questions. FIDIC 2017 doesn't define or directly address the concurrency, even no FIDIC version before it is completely. But in general condition, the word concurrent the red book, they say that there is no default concurrency rule in the contract. I mean, so it's a gray zone. Engineer determination, interpretation under the governing law, supplementary provisions like special provision in the particular condition. We are one of the firmest contract in Saudi Arabia which has a concurrency very clearly. Concurrent analysis you have to provide in order to get your money. Prolongation. So there are something called SEL protocol, SEL delay and disruption protocol. So FIDIC giving you the tool, not the rules actually. And we are referring normally while talking about the concurrency, the SEL protocol. So when the delay, the employer delay and the contractor delay occur concurrently, the extension time may be granted to the extent that the employer delay is shown to have caused the delay to the completion. But in the SCL protocol, second editions, which is Society of Construction Law, is talking about this. They say that when the contractor delay the completion, and if it is happened concurrently with employer delay to completion, then the contractor should entitled to an extension of time, but not compensation for the prolongation cost. So you get time, you don't get cost. Now, condition for the true concurrency, two or more independent delaying event. One is for the employer risk, other for the contractor risk. Both delay that affect the same critical path. Both occur during the same period. Neither delay is dominant. You understand? If the delay that are only overlap in the calendar time, but not in the impact, that is not a concurrent. I'll give you the quick example. If the engineer delay IFC drawing by 2 weeks, contractor equipment breakdown and some issues happen for the same 2 weeks. Both even delay the same critical activity on the critical path. So that is the concurrency. So that is one of the important things that we need to talk about. And another one is 8.6, which is delay caused by the authority. Delay caused by the authorities. What is this about? What is it about? So what FIDIC is talking about, this 8.6, we can quickly go through it. Delay is caused by the public authority. That can be a governmental agencies, regulates a local authority within the country or where the site is located. Many contracts. Delay from the authorities are gray area in many contracts. They say is a force major, it's a contractor risk, is it the delay caused by the employer? So the 8.6 is clear. Is a narrow relief when the authority action affect the contractor's ability to execute the works. I'm not talking about the bespokes here. I'm talking about the FIDIC. You understand? So if the contractor suffer the delay due to the action or inaction, I will say, of the public authority within that country, for the approval, permission, license, permit, whatever it is, then the contractor is entitled, maybe, for the EOT. So the authority is acting in its official capacity if and a contractor has diligently followed the procedure to obtain such approval. You sleep, ignore, negligent, laziness will not give you the entitlement. You understand? But here, you may not recover the cost unless your particular conditions say time. So in many countries, what are happening, public authorities control the project's input, like permit, utilities, customs, clearance, environmental, everywhere. The contractor cannot always, that's why, and many clauses, even they remove this from the bespoke, but they say that employer to assist the contractor get the permit. There is a clause in all, because they can't remove that. It's an unbalance, because the contractor is not always control these kind of things. Even the best effort, it's unreasonable to leave it to contractor failure. But also, employer also should not be penalized automatically to bear the cost. So since the delays from the authority are not necessarily employer cost, so there should not be a, I'm not telling should be, maybe, or it's up to you, but the cost is not reasonable. At the time, yes, time relief will be there if it's proven, no cost. So you should not passive, you have to be active to get that entitlement. If you are passive, you lose that, you know. So if your delay is within the country of the site and the delay caused by the public, as I told you, then yes, if you follow the everything, then that is affect the time for completion. Yes, you get the DOT. Why I told you that there is a wording at the delay public authority which is acting in its official capacity. What is that? What is that? So the authority must be part of the government, or that statutory function. The private sector's delay is not covered actually. If you say private sector, some authority, it will not cover. And that authority must be performing the regulatory or official function and within the country. Yeah, you can do that, right? So you need to issue the notice, you need to issue the full claims, evidence of the impact, program analysis, so that you get your entitlement. Then the engineer has a role on that, right? He has to either everything go through due diligence, and he has to review, and he has to determine that. You can't reject it automatically, or it doesn't even accept automatically anything, right? So extension of time will be there. Now I need to charge another one, which is talking about the rate of progress. If you know a project directors or the company owners or anyone always panic when they receive this notice of rate of progress. They panic. This is one of the most powerful tool that is engineer has to prevent the delay without waiting for the actual time for completion to expire. In a simple term, engineer has a contractual rights to step in early when the contractor is not progressing fast enough. even the completion date is still far away, you don't need to wait. So it's about the progress, right? It's about what contractor is supposed to do every day, every week. Sorry. You don't need to wait as an engineer. It's about staying on track. It's about bringing the contractor back to the positions on your reverse program. So if the contractor failing behind, the engineer doesn't need to wait until breach happening. You have to give the notice. But it's not a simple notice like others. It is heavy weighted notice. I will tell you why. If at any time the actual progress is such that, and the engineer's opinion, you have to mark this word, engineer's opinion. So the contractor is given the rights to him for his opinion. The works or any action or any milestone is likely to be delayed. It's not necessary to be delayed. Even it's likely to be delayed. Then the engineer can issue the written instruction. You have to, as a contractor, need to submit the revised program. And you need to propose the revised method of working. Maybe you need to make more manpower, more equipment, acceleration by your own, more shift of working. And the contractor has a very strict obligation to fulfill this. Even the contractor has a control that performance of work he is confident, but there's a limit, and that limit is the obligation to complete the work within the time for completion. But if that method of contractor, what he's doing is not fair enough or not sufficient, and the contractor is simply slow, and the engineer have a very good demand rights to correct it, action. Now you can ask, is this about the delay? The answer is no, not yet. It's about delay that has already, it's not about the delay that has already occurred. It's the delay about supposed to be happen, or we are expecting the engineer, or the threat of delay. What might happen if the current rate continues? This is why this is a preventive clause. This is a preventive clause. The contractor has to be act. You need to submit a revised program. You need to show that, etc. Manpower, method, sequences. Now, it's not entitled the contractor to pay extra payment or time. If the contractor need to accelerate, work overtime, adding more shift in order to meet the time for completion, your obligation. It's your obligation. It's a contractor own obligation. There's no variation. There's no additional cost to be provided. Then, if the contractor is failing behind due to the own mismanagement, poor planning, and the delays are not because of the employer default or fault, the contractor, you have to bear the cost. Don't argue on that. It can be trigger to the termination event, because that's why everybody panic when the notice come under there. You understand? So a termination start from this point, because it's not immediately happening. In fact, the engineer will give the opportunity to the contractor to correct before issuing the instruction. If the contractor can demonstrate that a delay is not critical or that recovery is already underway, then you need to demonstrate your good will to the employer. We are everybody. I mean, most of, I'm not talking about us, I'm talking about the construction industry. A contractor point of view, they always ready to be fight, defending everything, even your own fault. That will not give you the solution. That is, you need to demonstrate your goodwill, good faith to complete the project. You are mitigating, you are reasonably acting, you don't wait. So your communication is much important. Then your obligations you can demonstrate to the engineer, whatever it is. Again, if the contractor refuse or fail to complete with that instruction, if this failure continue after the warning, then employer has a right. There's a breach of contract and go to 15, failure to proceed with the due expeditions, which is terminations. It's not administrative, it's a warning signal. It's a warning signal that everybody have to take. It's very, very, very strict warning. Rate of progress. I think I have to stop here because I don't have a time. If there's opportunities we have, that's why I told her I can't complete. Even I made it very short, this close now. I didn't actually make as I want. We can talk about this close more than 10 hours even, because this is about very detailed understanding. I can't continue with that because the time is 9:45. So is that any uh, questions that we need to talk about? Admin, where is that admin? Can I talk to that admin?
Hi. I think as we planned this CPD for 2 hours and we are out of time. So what we can do is we can get the questions from the chat box and we will be sending you personally. And the replies will be sent to the participants from your response, hopefully. So we
I
can
can definitely respond to them. I can definitely help them. Even they can reach to my email. You can provide my email address that they can reach anyone so that I can answer to them. No problem. But the question should be very straightforward. If you don't understand, the question should not be argument. I have teach my point of view, and you can even deeply analyze. You can even talk about that. So with that note, thank you so much for 57 people attended, and thank you for the MCC PPA carvings. Always, um, um, I wish the success, and I'll be there for part of it to support the CPDs. Thank you so much, everyone.
Hi, thank you very
Thank you so
much,
much.
Mr. Gafur, for that insightful and comprehensive presentation. And I would like to thank everyone for your active participation. And also, again, a special thanks to Mr. Gafur for his expertise, where he has shared with us today. And I hope this session brought valuable knowledge and your professional journey. And we would like to inform you that we will be having our upcoming CPD sessions and events. And please follow us on our website. You can find the recorded video of this CPD session on our website. And that's it for today. Have a great evening and stay safe. And thank you very much for your participations. Thank you.